Yes, Mr.
Good morning, my lady. May it please, I appear on behalf of the appellants in this matter. If I just may introduce them, Sidra and Hassaan at the back of court today, accompanied by my instructing solicitor and her assistants. My own friend probably doesn't need any introductions. Mr. Post appears leading the appeal for the respondents, and Mr. Barnes appears as he did below. Thank you.
Now, before you launch into your submissions, if I can just indicate to all of you that we've had the opportunity, fortunately, to read extensively into the papers in this case, not just the judgment and the skeleton arguments, but also we've had the opportunity of looking at a lot of the source material, looked into the transcripts and read the relevant authorities. We think that the original estimate of a day and a half was in any event generous, but we would have thought that we could comfortably deal with this matter in the day, unless any of you think that that is wholly unattainable.
My lady, I think the estimate presupposed one thing, or at least catered for two eventualities. One was that the court wouldn't have the luxury of time, and secondly, that it wouldn't have at least one member of this court that's very, very familiar with this subject matter and probably forgotten.
Well, there we are. You see, I've got my trump card.
you do indeed, lady. I'm sure Lady Justice Davies has probably forgotten more about medical law than I've ever actually.
With great respect to you, I'm sure that's probably right.
So I'm very grateful. I was going to apologise in advance amongst my items of the housekeeping. I actually didn't propose to launch straight in, as it were. The paperwork has, or at least will have had the appearance of being unwieldy, and it's necessary to chop and change around in various documents at various different times of creation. It's one of the unhappy features of this type of appeal, where one's looking at forensic issues and the evaluation of them. So I make that apologies in advance, and I'm grateful for the indication, in particular, bearing in mind I know how much time and effort that must have put your lordships to. I am, to some extent, in the court's hands about how to approach the different issues in the case. I appreciate the court would normally say, well, it's your appeal, Mr. Stockwell, you decide how to present it, but there may well be things that you're particularly interested to get some clarification about, and I'm very happy to assist out of order, as it were, if that's of assistance. I was going to make another apology in advance. I remember the first time I appeared in this court about a little over 15 years or so ago, and I had to apologise to Sir John Laws, who was in your chair, because the case was about a procedural mistake, and it was, to use my dad's vernacular, something of a dog's breakfast. And in some respects, although the subject matter is very much more grave and important, this has some of the same features in that various different things have gone awry, both clinically and we would say in relation to how the issues were dealt with at trial. And so it's not the easiest thing, I accept, to pick your way through. The other point that I was going to make by way of opening or general housekeeping was just how the court proposed to deal with the pleading-related issue that's been raised.
Yes, well, we have had an opportunity of discussing that as between us. Of course, we'll listen to anything that either of you have to say about that. But we intend to simply hear everyone's submissions about everything to NASA, and any decisions we make about the pleading points will be contained in our judgments.
I'm grateful, my lady, and I think that must be the correct way in this particular type of case, because one of the issues would be the relative prejudice to both parties, and the court can't really consider that issue in isolation without looking at the substantive merits. With those bits...
Let me just check out. Is there any observations you want to make about that proposed course?
My lady, no, that's clearly appropriate.
Excellent, thank you. Yes, Mr.
Sorry, my lady, I should have checked.
Not at all.
Thank you. And my lady, just as an introduction, hopefully perhaps it's not necessary or quite as necessary in the circumstances given your indication, but rather than wade straight into the written documents, which I don't propose to labour over in great detail, particularly against the background of your indication, but start more with a synopsis or a canter through the issues as we would see them. We say that although it might not have that first appearance, that a properly analyse the case is actually a relatively simple one. Or at least I take the position that if I can't persuade you it's simple, then I'm probably dead and buried in the grand scheme of things. If we have to delve into the detail, then it's going to be probably to the respondent's advantage rather than mine. We say, and I will caveat this in due course, that the actions of Mr. Minhas, the defendant's neurosurgeon, were indefensible when looked at objectively, and that left the unhappy situation that Mr. Malik had surgery that he may not have required, I put things neutrally at this stage, and he had an operation that he may not have given him his consent for if properly advised. And we say that the uncertainties in the case, both for His Honour Judge Blair QC and for this court, arise in consequence of negligent admissions by Mr. Minhas. And we say that the court really needs to start by examining whether or not that last proposition is correct, whether or not he was negligent in the conduct of the consultation. In particular, obviously, as to the duration of Mr. Malik's symptoms, and whether separately that issue or that question or the answering of that question was material to him when deciding to recommend surgery, and was material to both him and Mr. Malik in connection with the consenting process. The next observation I think it's proper to make is that we say liability should attach to the defendant, but were liability to attach to the defendant, not to presuppose the court's assessment of the issues, it would be doing so in the particular circumstances of this case. It's a very odd combination of events, both clinically and in the course of the trial, and this case would really be pretty much on its own facts. And obviously, as counsel, I'd like to say that my case is really important and could be relied upon by lots of people for various different purposes, but I don't see that as being this case. The counterpoint to that, alternatively, if the court dismisses the appeal, then we do say that it would give, at least the possibility of licence to people that were far less scrupulous than Mr. Minhas. It's a point that I made towards the end of the substantive skeleton argument in the appeal, that this is one of those cases that could have, or the judgment in this case could have unforeseen circumstances where the court to accede to the respondent's position in relation to it.
Right, are you basing that solely on the point that he admitted that he didn't ask for the duration of the pain? Is that it?
But both in relation to the position over the examination or consulting process, because that has an importance, the importance that was attached to it in the case of FB. But I do make this point that to some extent the acquiring of information by the surgeon in this case, but it could be any medical practitioner, is one side of the same coin with informed consent, in that you can't properly inform somebody else without properly informing yourself. So that's germane to the giving of any professional advice. So I would pore over papers before having a consultation. A clinician would have to look at records, look at imaging, or other investigations were they available. But more particularly, he would have to, or she would have to, ask questions of the patient that was in front of them. And unless and until the clinician, or any other professional for that matter, has conducted that exercise, he or she can't properly obtain the informed decision or consent in a clinical context, unless that exercise has been undertaken. As I say, I would see them, or would urge the court to see them as effectively two sides of the same coin. On the one hand, the clinician informing themselves, or on the other hand, the patient being informed. So we say that at least if the judgment were framed in a particular way, that it might have unforeseen circumstances eroding the importance attached to both those exercises. And so I say that not wishing to make any more of the appeal than I would like to. I'm keen on my client's behalf to see what they would regard as a just outcome to the appeal. The second point that I'd make, and again I make this hopefully with the court's indulgence, is to look at the case from the perception or from perhaps a human element regarding the various parties. I've been struck dealing with personal injury matters in particular. There certainly aren't too many clinical negligence matters where there's any concern about malfedes on the part of the clinician. But I've been struck in the course of my practice that you would imagine that there would be some malevolence or in some cases, but more often than not, cases go or situations go awry because people have had the best rather than the worst of intentions. They've been trying a little perhaps too hard to achieve a particular outcome. And so there certainly aren't any villains of the piece in this particular case. Mr. Malik, where he here would have wanted me to make that plain. He had a really rough trot, and again to put matters colloquially, he'd had his initial problems linked to a long history of constitutional degenerative change to his spine, which had ultimately culminated in him being a patient of Mr. Minas's for the first time back in 2014. And that was surrounded by some equally unfortunate personal circumstances for Mr. Malik, in that his relationship had broken down. He became homeless, which is in part why some of the difficulties arose about the follow-up in relation to his care. So he had surgery in circumstances where, even with the vagaries of how things are in terms of resource demands within the NHS at the moment, he would have been expected to have something by way of rehabilitation, follow-up, physiotherapy, and he was in effect lost to that, as people would describe it. And
sorry, you're talking about the first operation?
The first operation, yes. Lady.
Sorry, I thought I'd read in the papers and the rehabilitation reports and so on that he'd been in a rented flat.
That's correct.
But he lost that after the second operation.
No, my lady. I think there were various different difficulties. Both
it may not be relevant. I mean, he obviously was going through a difficult personal time.
He was, my lady.
Which impacted on all aspects of his life,
Well, including continuity of care, my lady. Yes, because he came to Mr. Minas in 2015, so that's after the first operation, against the background of various letters and various different things having gone astray. Now, if I turn to, sorry, just before moving on in relation to Mr. Malik, a lot's been made of whether he was desperate to have surgery. He was quite clear in his evidence about this that he wanted to get better. He wanted to be able to re-establish some normality to his life, and he placed particular importance to being able to work, because without being able to work, he wasn't able to support himself, and in particular, he wasn't able to support his children in the way that he would have wished. So that was figurative in his thinking, and he said in evidence that was something that he discussed directly with Mr. Minhas. But nobody's desperate for surgery. So nobody's desperate, for example, to get a ticket for a heavily oversubscribed event. Nobody's desperately keen to get a reservation for a new restaurant. What they're keen to do is to either go to a concert to see their favourite act, or go to a restaurant that is particularly well recommended to them. But the ticket or the reservation are incidental to what they want to do, and in the same way, the surgery was incidental to Mr. Malik obtaining or trying to establish some greater normality in his life. So the characterisation of him desperate for the surgery per se is not an accurate one. In itself, that is. Turning then to Mr. Minhas, if you've got that far and you've read the transcript or read at least the excerpts of the evidence, you'll note that Mr. Todd, the claimant's neurosurgeon, was particularly glowing in his description of how Mr. Minhas had conducted the surgery itself, in particular the second operation. The task in many of these neurosurgical cases is to create as much space against the background of compression causing the type of difficulties that Mr. Malik had experienced. And that is a very fine balance for the surgeon exercising particular care and skill, because the surrounding areas are prone to injury, particularly the spinal area. And so there really is a tension between trying to create as much space and remove or whatever material is causing the offending problem, whilst also not avoiding any injury taking alongside. And as I say, Mr. Todd in particular, and this view obviously was endorsed by Mr. Ivanov, the defendant's neurosurgeon, was very assiduous to compliment Mr. Minhas on the way in which he conducted the surgery itself. He clearly is a very skilled neurosurgeon, and he was clearly keen to try and assist Mr. Malik. And I say that not just because of him offering the surgery itself, but when one looks at the medical chronology, he did a variety of different things to try and assist Mr. Malik, and one can only assume that because Mr. Malik had the difficult situation that he had the problems over his accommodation, he'd had the problems of a poor outcome following the first surgery. Mr. Minhas had some sympathy for his position, and that's perhaps best demonstrated by the fact that he wrote a very forceful, detailed letter on behalf of Mr. Malik in connection with his housing. And that's not something that a surgeon necessarily has to do. It's the type of thing perhaps more commonly one would see a GP doing it, but it's something that he was assiduous to help Mr. Malik, not just in the way that a surgeon would do directly in terms of operating on him, but he was assiduous to try and help him in different ways. And the other striking feature is that although things went awry a second time, and the position worsened, and Mr. Minhas, for his own part, didn't achieve his aim of trying to improve life for Mr. Malik. Nonetheless, he stayed involved for a not insignificant period of time, trying to arrange a variety of different treatments, including some of the measures perhaps that might have been considered in a different order. But it wasn't as though he metaphorically washed his surgeon's hands of Mr. Malik immediately after the second operation. He stayed involved for a not inconsiderable period afterwards, and was obviously keen to try and do things to assist him in the circumstances that Mr. Malik found himself. So that throws open something that perhaps is peculiar to clinicians. So this probably my lord and my ladies probably haven't had this situation where you thought, well, I wish I could have run that trial again, or I wish I could have run this case a different way, or second time round, hoping for a different event, because ordinarily it results in an outcome, and that's the end of matters. But of course, Mr. Minhas found himself in a different situation. He found himself in a situation where he thought, not unreasonably from a physical point of view, in terms of the outcome of the surgery, that he could achieve a better outcome in terms of a greater level of decompression, and hopefully put Mr. Malik in a different position, so he had a second bite of the cherry, as it were. So his actions in having a commitment to surgery are perhaps equally understandable to Mr. Malik wanting a different outcome, a favourable outcome, or at least more favourable than the one that he was left after the first surgery. So the defendant, that is the trust and their representatives, can perhaps not unreasonably feel a bit aggrieved that the case took on a different course at trial. It'll be a matter for the court as to whether or not we should be allowed to proceed with the case in a slightly different way. You might say it's not a slight but markedly different way, and again, I don't presuppose the court's resolution of those issues, but I can perfectly well understand why the defendants take the stance that they do, both in relation to the pleading point and the defence of the appeal. I'd also include, not to be in any way discourteous to him, His Honour Judge Blair QC, in terms of him being put in what I would suggest is a difficult situation, again with an evolving case. One has to look at the reasons why it evolved in the way that it did. But this court is being, in essence, asked to speculate on whether His Honour Judge Blair QC did or didn't reasonably infer various different things, and in turn, His Honour Judge Blair QC had to fill in various different blanks when really these blanks shouldn't have been in existence at all. If Mr. Minhas had done what was reasonably required of him, made sure of his ground in anticipation of advising Mr. Malik, and clearly explaining and documenting what he did and why contemporaneously. So both His Honour Judge Blair and this court have placed in some difficulties that were avoidable. My lords, I really hesitate at this stage because I really am transgressing on your area, but bearing in mind the way in which the case is responded to, I think it's probably sensible to say something about the appellant's position in relation to how to approach the different types of question that are before the court in the traditional sort of nomenclature of facts, law and mixed questions. But I'll do so very briefly. Clearly, some of the findings that needed to be made by His Honour Judge Blair were clear findings of fact, and that's why, in this case, notwithstanding Mr. Malik's instructions prior to trial, there was no appeal against the finding that he had complained of intercostal symptoms, because that was eminently of the type of question that was for His Honour Judge Blair. We still say it's somewhat odd, and of course this court's still going to have to look at that history in the context of the pre and post clinical position, because there are certain vacuums that still need to be explored for the purposes of the resolution of the appeal. But we can't properly appeal that fact. In fact, we didn't seek permission. We're very clear about that. The straightforward, as it were, legal position, again, there shouldn't really be any issue between the parties in this respect. There were no substantive disagreements of law in the respective opening or closing documents. There were the usual arguments or differences of opinion in relation to the application of them, but the law was relatively clear and well settled according to both parties.
And that was acknowledged by the judge and set out succinctly.
At the beginning of the judgment, yes, my lady. The difficulty, we say, and again this is the question for this court, is that when it came to apply Montgomery in particular, we say that the judge placed his own gloss on Montgomery, and what he said was both contrary to law, or at least contrary to a correct application of Montgomery. And indeed, it was contrary to what was advised by both surgeons, neurosurgeons. And of course, I'll come on to deal with that in a little bit more detail, if I may, when it comes to the discrete question of informed consent. And then the more difficult area, and the one which perhaps unsurprisingly is more controversial between the appellants and the respondent, is how to approach the mixed questions of fact and law, of which there are some, and they happen in this particular case to be the more important ones, particularly with reference to the issue of causation. And when I had perhaps a higher or more enthusiastic assessment on my own intellectual and advocacy abilities, I did some public law work. I still do some protection work, but I had designed as doing judicial review cases on a regular basis. And in those cases, obviously, there is a stark difference between procedural and substantive matters. So you can have a case where the court remits a case because certain hurdles weren't worked through. And the key question in many of those cases is whether something was left out of the account, something that should have been taken into account was omitted, or conversely, if something should have been taken into account, it wasn't. If something irrelevant was taken into account, then that had the same vitiating effect, as it were. And we say that in the context of causation in particular, Mr. Minhas left the duration of symptoms out of his account when making his decision. And with respect to him, His Honour Judge Blair appears to have repeated or made a similar error in terms of his approach. So, using what might be more familiar in a public law or administrative context, if one adopts that approach, then we say that the court is not bound and should not follow findings that, in a sense, have been reached, either leaving relevant matters out of account or arise, particularly in the context of the informed consent findings, as a result of what we would say was akin to a misdirection of law. And what the court shouldn't permit is, in effect, the respondent to, I don't mean this pejoratively, but in a sense, cherry pick the bits of the judgment that meet its convenience, when some of those have been resolved fairly and squarely in the exclusive provenance of questions of fact, and some of them are mixed questions where the judge had gone awry. And finally, if I can address some of the other underlying principles briefly, so that at least it's clear to my learned friend when we come to hear from him in due course. We accept, we must accept that the burden of proof is on the claimant. We do say it's modified slightly in cases such as this by a benevolence principle, and reference has been made, and I'll expand in a bit more detail in a moment on the cases of Wisniewski, Keith, and JH. But the reality is that it's probably going to be possible for this court to determine all the issues without actually having to strain or bend too much, but just actually making its own findings of fact. One of the issues that's raised, which I can put the court's mind to rest about in the respondent document, is we're not saying that Mr. Malik was entitled to judgment without more, because we say there was an absence of informed consent, and in particular, Lady Justice Davies dealt with a case of Diamond, which met this issue head on. We're in the, I don't know if it's a happy or an unhappy position, because we don't know what it will say and how helpful it will be, but we're in the slightly unhappy position that the Nicola case, which I've mentioned in the supplemental document, is currently before the Supreme Court. I understand that's going to be heard in May. Obviously, judgment in that matter won't be for some time afterwards. That case is going to give some consideration to, as I understand it, to the question of whether or not any gloss can be placed upon Montgomery, and you can import some degree of reasonableness or Bolam considerations to what the doctor does, in a sense, put on the table for the patient, and in terms of different options. But the other issue, or at least one of the other issues in the case, as I understand it, is whether or not there should be a modified causation test in relation to informed consent cases. So in effect, would it be a challenge to the court's decision in Diamond and Royal Devon and Exeter? Obviously, that's not open to this court, and I don't urge that upon this court. But what we do say is that the court will have to consider the question, obviously based upon its own determination of which of the facts it's bound by, which of the facts it would draw inference about, and what it makes of the position. But essentially in these cases there are two, or there tend to be two types of situation. There's the one where there's what might be described technical or minor deficits in the consenting process. To give an example, perhaps you've got somebody is told there's a X% risk of something happening when the risk is actually slightly higher. But the information about the risk is given, and the materiality of being told it's 5 rather than 10% is something that the court would have to consider. And then there are cases where the consent is obtained on essentially an entirely false premise, or the exercise in relation to obtaining the patient's consent is either wholly or largely defective as an exercise. So two ends of the same extreme. So when considering the submissions that I make, in particular in relation to the informed consent position, I would urge the court to adopt, perhaps, or suggest perhaps the following approach, that where the consenting process is far removed from what would be reasonably required in the circumstances, logically the court would be more ready to infer that a different decision might be made. So if there was something on the one hand that appeared to be of a technical or perhaps superficial character, then the court might need very good evidence from a patient that very small change in information would have made a big difference to them. Whereas somebody that effectively had very poor information, incomplete or non-existent information made available to them, the court should be more ready to infer that the outcome of that deliberation would have been different. I would suggest there's a logic to approaching cases in that way, and it also strives at fairness and protecting the principle of informed consent itself. And then one last observation before I move to the two documents, which I only propose to be relatively brief with separately. Both documents for the appellants and the respondent presuppose that the court can make a decision one way or another, but then of course that's something that this court might not consider it's able to do. The case can't be the subject of a retrial because Mr. Malik is not here to further elucidate somebody. There are cases which are remitted with guidance, but again, that doesn't seem apt in this particular case. But this court may nonetheless reach the view that it really can't say what Mr. Malik would have done one way or the other if Mr. Minhas had adopted a different approach in relation to the consenting process. So in those circumstances, we suggest that the correct approach for the court would effectively be to put Mr. Malik in the same category as Mrs. Chester, in the case of Chester and Ashford. So in that case, which no doubt at least one, probably two, possibly all three of your Lord and Ladyships will be familiar with, the patient was in the unusual position of not being able to say what she would or wouldn't have done given the correct advice, so the breach of duty was ultimately established. The case had perhaps a similarly unhappy procedural history in that this point over causation wasn't actually pleaded in Chester, so the same complaint was made by the defendants in that case. It was renewed to the Court of Appeal and it fell by the wayside when the matter went up to the House of Lords. But in that case, Chester wasn't able to say one way or the other, rather than saying, as most patients would, no, if I had the correct advice, I would have adopted for a different course because I've had this injury, and who would want to be in the position that I am. Logically, if this court thinks, well, actually, we can't really presuppose what Mr. Malik would have done, then he falls into an analogous category as Chester in the sense that Why would he be treated any differently? So we say that, so far as the consenting process is concerned here, that it would fall into the latter category, and that it was, to all intents and purposes, absent because Mr. Malik was presented with a binary decision, surgery or no surgery. He wasn't being offered any alternatives. And the other particular complaint that was made below was that he wasn't given time and space to reflect upon that and discuss it again, because everybody was agreed that the decision for surgery was made on the 13th of July, rather than at some point prior to the 13th of July when the surgery took place on the 13th of August. And that, as I say, is inconsistent with the approach that's been advocated and the approach that's been adopted in the other cases, more particularly Montgomery itself. And I hope that was helpful. I just wanted to set out our position in a nutshell, if I might. So if I can take your Lord and Ladyships first to the final court bond. And perhaps most easily my replacement skeleton argument at page 104. I've already been through the background, and the court's already indicated that it's familiar with what's happened, so I won't repeat the first 14 paragraphs of this. We say that, to a lesser or greater extent, that there was broad agreement between the clinical experts about what should have happened in terms of the history taking and the import of that information. I appreciate different people were asked different things in different orders, and again, that doesn't lend itself to aid the judge that's dealing with the matter. But nonetheless, all the constituent components of their respective opinions sat comfortably together. The court will have looked at the joint statements which didn't deal with these issues. But when one looks at the extracts from the transcripts that were cited in the claimant's closing submissions and are referenced on paragraph 16 onwards in the appeal skeleton, it's quite clear that there was a need. Neurosurgeons accept there was a need to ask Mr. Malik about how he came to be in the situation that he was with this new complaint of intercostal symptoms. And unfortunately for him, we say, the surgeon effectively skipped from the S of Socrates to the end S of Socrates in the mnemonic, which is referenced in my skeleton argument, from sight to severity, and missed out all the antecedent steps that would be necessary. And when one looks at the other reported cases, the attention to which was urged upon His Honour Judge Blair, that have dealt with the question of consenting in relation to spinal surgery, one would reasonably expect, and one in fact sees, the history including when did you first experience this pain? What was the onset in relation to it? Is it radiating? Now, to a lesser or greater extent, that does appear to have been explored, because the pain was contrasted to the lower lumbar related problems, which are of sciatic nature and were clearly documented as radiating. So the court might draw an inference that Mr. Min has had in mind that this was a different type of pain, and of course there was some consideration between the experts about to what extent it was possible to differentiate between different types of pain. But everything else, is the pain eased by anything? Is it constant during the day? Is it something that affects you more in the morning, or is it something that keeps you awake at night? None of these questions were addressed because Mr. Minhas confined himself to the inquiry that do you have this pain, and how would you describe it, rather than any of the other questions that would commonly be asked by anybody, whether they were attending their GP or they were attending hospital, or they were in the consulting room with somebody like Mr. Minhas.
Well, can I just ask this? You've accepted in paragraph 12 of your skeleton that Mr. Minhas had reasonably concluded that a significant proportion of the intercostal pain was radicular in origin, hence potentially amenable to decompression surgery.
Yes, my lady.
Well, having made that acceptance, really, how much further is this point you're now making taking this?
But just because the essential character of the consultation was defective, that was just one component of a whole number of components. I mean, the reality is, my lady, just again to kind of put it in simple terms, you can't go to your GP at the moment and get antibiotics for a sore throat without the GP going into a greater degree of detail than Mr. Minhas did in this consultation. He'd obviously undertaken the MRI investigations. He'd had the history as reported to him in April. He wasn't expecting Mr. Malik to turn up complaining of a new problem. But what happened then was that this got essentially tagged on to a consultation that was originally planned and organised to deal with other matters. And so it wasn't just an add-on, it wasn't just another minute of a 10-minute or 5 minutes of an hour-long consultation. This was a new problem. It may have arisen in the context of somebody that had degenerative problems to the spine. It may arise in the context of somebody that had previously been treated surgically at mid-thoracic level, but this was a new problem. And it needed all the care and attention that a new problem would reasonably demand from any clinically qualified professional, including all of the considerations: site, onset, character. Is the pain associated with something else? You couldn't just ask the question about where does it hurt, how bad is it, and leave the questioning at that. That is essentially what happened in this case. Nobody has suggested otherwise. Mr. Minhas had made, wasn't a concession as such, but he'd agreed with the evidence in the case that you treat patients, not scans. So you can have a scan on the one hand that shows limited basis for an intervention, and you can have a scan on the other hand which shows very significant degenerative change or compression. But what you need to do in each case is take a full history from the patient and elicit their symptomology and make a balanced decision. And although Mr. Minhas accepted that what had been said by the neurosurgical experts in their respective reports and what it said in terms by the pain specialist, that you treat the patient, not imaging, to a lesser or greater extent, that's essentially what he did. He didn't ask him all the questions that you would normally expect somebody to elicit as part of a proper pain history. And he accepted, although no separate complaint was made about it, that he didn't make an examination of the patient. Whereas, as I say, I can't get antibiotics from a GP without essentially giving the GP my immediate life history for the months or weeks leading up to that point. But here was Mr. Malik being advised and consented in the same consultation for major surgery with a significant attendant risks to his mid-thoracic spine. So, my lady, it is relevant. The differentiation between the pain informed the discrete question about whether or not the pain would be amenable to surgery, and the concessions properly made because Mr. Todd properly made the concession in the course of his evidence. But it was only one part of an adequate defensible consenting process, or sorry, a consulting process, rather, my lady.
Mr. Stockwell, I'm sure the fault is mine, but I'm looking at your grounds of appeal, which are concise. Your first ground of appeal is that the judge was wrong to hold the responsible body of competent and reasonably researching the Bolam test would have offered Mr. Malik revision surgery at the relevant level, and then it's this, in the absence of any inquiry or knowledge about the duration of his associated pain. That is the factual point you're raising.
Yes, my lady.
So, as I say, I'm sure the fault is mine, but why are you dealing with more length, at this length, with other questions that may or may not have been asked, when that is your quite specific ground of appeal?
My lady, I make it to set the questioning in context. The question about how long had the pain lasted was not asked, and that essentially was a gateway question. It was the second question that's logically asked. But after that, then none of the questions or the information that would have been incidental to starting along that path. So every path starts with a single step.
Well, so what you're suggesting now is that we have to regard that as just the a preliminary part, and actually, if you chose to, you'd have pleaded at A, B, C, D, and E after that. You know, failed to examine him.
No, my lady.
Failed to ask 90 supplementary questions.
Sorry, my lady. I think we are at cross purposes. I just say that it's part of a context. When one's looking, as the defendant respondent is doing, to exculpate Mr. Minhas for the way in which he conducted the consultation, the critical question, because all of the evidence focused on that issue, was what was the import of the duration. So, my lady, I fully agree. I'm not raising a separate argument, but I'm setting.
Well, you do, with respect, you do seem to be saying, and I think you said that the whole of this was completely indefensible. The surgeon's approach to obtaining consent.
Well, I do, my lady. Not because of not going through all of the different points, but I do say it on the basis that not asking that critical question makes the exercise indefensible.
Which exercise?
Well, both the advisory and the informed. I do want to make sure I am being clear to the court. Apologies if I have created any confusion on the court's part.
It's just that it seems to have expanded very considerably over and above the very admirably tight way that you drafted your grounds of appeal.
In which case, maybe the easiest way of reassuring the court is I'm not asking for permission to raise any other issues. I'm not raising any issues. They weren't explored in any detail. Perhaps mistakenly, I thought it might be helpful to the court to consider that question in the context of how Mr. Minhas had undertaken the exercise. But if I'm mistaken in that regard, then I'll just focus on the delay. But as regards the duration point, we do say that in essence is our case, that fundamentally undermines both the advisory process and the consenting process, for the reasons that we say were fully and perfectly adequately explored, both with Mr. Minhas and with the experts in the case, because it wasn't possible to properly evaluate the effectiveness of alternate options, including doing nothing at all, without obtaining an answer to that question. All the experts, by perhaps slightly different routes, were agreed that question needed to be asked, and they recognised the importance of that, because there was, on the one hand, the potential for a spontaneous resolution of symptoms. So for all Mr. Minhas knew, and therefore for all His Honour Judge Blair knew, or this court knows, or I know for that matter, on the finding of fact that His Honour Judge Blair made that the the symptom was reported, we don't know whether or not Mr. Malik rolled out of bed with that problem that morning, or whether he'd had it for a longer period of time. All we know is that it was something that he complained about for the first time in that consultation.
Well, it was the first time he had been seen by Mr. Mihas. He had had a previous appointment on the 27th of April. There had been a GP appointment, which you mentioned, and which is in the supplementary bundle. But it was the agreed evidence of the two neurosurgeons that the problem had probably been in existence for a couple of months, and that was accepted.
No, my lady, that's not correct. For no longer than.
For no longer than a couple of months.
No longer than a couple of months, my
Very
lady.
well, I'm willing to be corrected on that, but for no longer than a couple of months.
For no longer. But it was, the
Which
reference...
is what the judge found at 87.
That's correct, my lord,
That's
yes.
a finding of fact.
For no longer is any time between the 13th of...
Yes, it's a
13th
finding
of
of
July.
fact.
It is, ma'am.
It's not specific to a
No.
day, but
No.
it could have been going on. It could not have been going on for more than a couple of months.
That's correct.
That's the
That's
time
correct.
frame.
So,
And that's the finding again that you can't challenge.
well, no, I don't seek to challenge that finding, but that finding's not a perfect answer to the question that
There are
Mr.
lots of judgments that we see. There are lots of judgments we give which don't contain perfect answers to every question, because there are times when you can't have a perfect answer.
Well, my lord, it's more fundamental than that. So the reason we don't have an answer to that question, the reason that the judge wasn't in a position to answer that question, is because Mr. Minhas didn't ask Mr. Malik. I hope there won't be any disagreement from the proposition that I make in my made in my opening statement, that he can't, Mr. Malik that is, can't be criticised for not remembering. It's something that patients don't do particularly well, and that, as I said in my supplemental document, is the precise reason why we have or place the significance on being able to have the benefit of a fully elicited and well-documented history by medical practitioners. That's why it's so important. But on this question of the question of duration, all we've got, my lord, is a long stop. So it could on the judge's finding, which I fully agree, I cannot disagree, cannot go behind. This court can't properly go behind. We have a long stop of up to a couple of months, but that doesn't mean that the pain was present longer than a day, 2 days, 3 days, any point during that period. So that finding in no way confines the appellants in the appeal. It didn't confine the judge. The problem that the approach the judge adopted is that he didn't then go on to ask the separate question, which we urge upon this court, is where does that leave? Or where would that have left Mr. Malik, and where does that leave the appellants? Because that question couldn't have been answered with greater precision than the trial judge answered it. Perfectly well understand why he was in the position that he was, but that doesn't answer the separate question about why did the judge, why did Mr. Minhas end up in that situation? That was because there was a failure on Mr. Minhas's part to elicit that part of the history at least, and he needed that information to be able to make the recommendations that he did, because he couldn't. If Mr. Malik had said to him in answer to that question, I've only had that problem since yesterday, then everybody was agreed that it would have been rash for him to recommend surgery, or at least that was Mr. Ivanov's description of matters. There was an attempt to utilise the period between the 13th of July and the 13th of August as, in effect, a cooling off period or an opportunity to wait and see and whether or not the symptom improved. But of course, that was not figurative in Mr. Minhas's mindset. He wasn't delaying the surgery. He went straight out, as the evidence makes clear, from the consultation list that he had on that particular day, filled out the surgical requisition form, which is in the bundle and is extracted within the records that the court's seen, and he wrote on that document, I don't think it's in dispute, but he can take your lordships to it if required, his expectation that the surgery would be performed in 3 weeks, not the month that it actually took. He wanted the surgery to take place on Mr. Malik's behalf as quickly as it could do, and obviously that suited Mr. Malik in the circumstances that was the treatment that was recommended to him. But the problem that is created by this imperfect finding, or this finding which, with respect, is no more than a long stop, is that we don't know, or we can't know, because Mr. Minhas didn't ask, where Mr. Malik would have fallen between those two extremes. And in those circumstances, it wasn't reasonable to make the recommendation that he did, because he couldn't counsel Mr. Malik about whether or not his symptoms might spontaneously resolve. If, for example, he'd been told that the symptoms had happened or occurred effectively the day after the consultation had taken place in April, then we wouldn't be here. There wouldn't be any legitimate complaint, because Mr. Todd, for his part, Mr. Ivanov, for his part, all agreed that if there had been a more significant duration of symptoms, then the prospects of a spontaneous resolution or mitigation of those symptoms by other means wouldn't have been particularly optimistic about it from a clinical point of view. So yes, I am, or the appellants rather, are stuck with the finding that it was no more than 2 months, but that's not an answer to the question that must be asked of this court in the case. The question is...
Another finding of fact by the judge, they're set out really in paragraphs 86 and 87. Namely, that the judge said that the claimant wasn't able to persuade him that he was not complaining of very serious and debilitating intercostal pain when he was seen on the 13th of July, and that pain was clearly acute and demanded speedy intervention for its relief. Now that no doubt goes to the fact that the surgeon then sought to bring the operation within a reasonable time to deal specifically with the extent and nature of the pain
Yes, my lady.
the claimant was suffering,
Yes.
and of which he was complaining.
Yes, my lady.
And that is a fact of which the doctor could properly take account.
Yes, my lady, but it still begs the question as to whether or not, I mean, trying to organise something as quickly as possible is perfectly reasonable. And that step was taken by Mr. Minhas against the background that Mr. Minhas perceived, and the judge found, that Mr. Malik was exhibiting and experiencing and describing severe pain. So all of that I fully accept were findings that were open to His Honour Judge Blair. They were broadly consistent, in fact, with what Mr. Malik said himself. I think there was some nuance about whether or not he, well,
Really?
the character. Sorry, no,
That's
the
not my
character.
reading of it.
No, the character of the pain. He was saying, so far as the pain that was affecting the lower part of his left leg, he was saying that wasn't of a severe character. I think Mr. Minhas was saying there was the severe pain in the intercostal region, and Mr. Malik was saying, no, I don't recall having that. But the general categorisation of the pain, there was a slight discord between whether or not both were regarded as being severe, or it was just the severe banding across the intercostal area. But my lady, that does beg the question, or at least leaves an issue about whether or not it's reasonable to recommend surgery in the first instance, because it's only reasonable to recommend surgery in the circumstances that you know how long the problem has been been present, because if you don't know how long the problem has been present, then you can't properly inform and advise yourself about whether or not to make the recommendation, because the shorter the period of time, the greater the prospect of a spontaneous resolution. So if you had a patient and you were saying to the patient, well, I can operate on you for this particular problem, have surgery, you'll have all the attendant risks, recuperation and the rest of it, but equally, we might be sat down a week from now and that pain has disappeared, then one wouldn't presuppose that the patient would effectively just then say, well, no, actually, let's get it over and done with, and you operate on me today or tomorrow or whenever it might be. So the severity of the pain entirely justifies the course that Mr. Minhas did in expediting the surgery, but it doesn't address the question of whether or not it was reasonable for him to recommend it at all against the background of the uncertainty over the duration of symptoms. They are, with respect, my lady, two separate questions that he had to ask himself. So he had to ask, what
I think, Mr. Stockwell, that's the third time you've made that submission. So I think we have that.
Sorry?
That's the third time you've made that submission.
Which
but
one?
They're separate questions, and you should have asked how long. That's the key point under ground one, isn't it?
It is. Sorry, I was only making the point in answer to Lady Justice Davies'
we have that.
point. Sorry, I'm
No,
sorry.
not at all. It's a key part of your case, and it's most important that we have it put as you wish to put it.
I'm grateful, my lady. As I say, I just think it's very easy, my lord, and I'm hoping to assist the court in not conflating what were essentially different components of the same decision-making process.
And as I'm understanding your submissions on this ground one, is that without asking the specific question, it could not be known whether there was any hope, possibility, likelihood, aspiration, call it what you like, of some sort of spontaneous resolution of this very significant pain.
Yes, my lady.
You say that therefore, that question not having been asked, Mr. Malik was put in a position where he could not possibly be deemed to have given a proper informed consent to the surgery.
My lady, the antecedent part of that, or the intermediate part of that, is that Mr. Minhas couldn't give the advice. Mr. Malik couldn't give us.
I've leapfrogged.
Sorry, I'm just very keen that the court separates
you're
everything
absolutely
out.
right. So the step change. I missed
Change.
a
I'm
step.
sorry.
No, don't apologise. I mean, I summed it up, and it's for you to tell me if I've got it as you wish to put it. So you say that the middle step is, if he hadn't asked the question, he wasn't in a position properly as a neurosurgeon to give the full advice, and he not having been able to give the full advice, Mr. Malik wasn't able to take into account and weigh up that advice and thereafter make an informed consent.
Yes, my lady. All set in the context of this being, as everybody accepts, a new complaint, so it wasn't something that Mr. Malik or Mr. Minhas had a conversation about before.
Well, you say a new complaint. That slightly begs the question, doesn't it? It was a
Sorry,
complaint that had not
you're quite right to
previously
correct me, my
discussed
lady. Yeah.
as between the neurosurgeon and Mr. Malik. The question of whether it was actually a new complaint is at the heart of your submission.
Well, I think we're then. I might have been using a complaint in a non-medical term. It was Mr. Malik complaining about something for the first time, whether or not it was a long-standing medical complaint. So apologies for the confusion.
No need to apologise. I just wanted to make sure that I'd got the way you wanted to put it exactly right, and I think we have.
Because of, again, without sort of hopefully repeating the position, if, for example, a particular answer had been given to that question, then Mr. Minhas might have said, well, now, hang on a minute, you might be keen, and I'm keen to offer you a speedy relief to your suffering. But let's not jump the gun here, because this is something that you might wake up and either the problem might have gone away, or for that matter, the problem doesn't have to go away. It just has to be less excruciating than it was found to have been by the trial judge. So that the evidence from both the neurosurgeons and the pain specialist was agreed. There's a nuance to the position between Dr. Valentine and Dr. Sanders, which it might be helpful just to explain at this stage. I think I probably
take us to their report, or to their joint report.
It might be just easier to explain it. I'll try and explain it, because it may be that it's not confrontational, but I can certainly take you to the references to their evidence in the transcripts if it helps.
You explain the nuance as you see it that you want to take into account.
There was a semantics, not the right word. There was a philosophical difference between Dr. Valentine and Dr. Sanders in at least one part of their evidence. Dr. Sanders, that's the respondent's pain specialist, wasn't prepared in the course of his examination, cross-examination that is, to speculate as to whether or not Mr. Malik's particular complaint fell into the category of those which might have improved spontaneously or might have been amenable to other conservative medical interventions. And the reason that he adopted that position is essentially that he didn't know what the position was in relation to Mr. Malik's case. So it aligns very conveniently with your ladyship's point about the complaint. So we don't know how long the complaint has existed, the source of Mr. Malik complaining. And so against that background, Dr. Sanders' position was that, well, I can't speculate upon whether or not Mr. Malik's symptoms would or wouldn't have improved spontaneously, or wouldn't have been because I just simply don't know. I've got a vacuum, because we don't know what the symptoms were beyond the 13th of July, beyond any inferences that the judge below drew or this court might draw. And he had the surgery, so beyond the position of the surgery, then it's very difficult to know what the position would have been one way or the other, because there's been this intervening event. And it was encapsulated by the learned counsel that was leading me, Mr. Nifton KC, in that because a single complaint, if it resolves, is of short duration, but the longest of complaints starts with a single day's worth of pain. So every chronic condition starts by being something that could be one or the other, and you don't know. So to that extent, there was a small measure of difference between Dr. Valentine and Dr. Sanders, but there was an acceptance that Mr. Malik could have fallen into either categories. The philosophical difference is whether you say that this individual's case was likely to had a prospect of spontaneously resolving, because it either did or it didn't. We just don't know, because there wasn't the opportunity for events to take their course without the interference that did took place. I don't mean interference in a pejorative way, but the kind of novus actors, as it were, of the surgery taking place. So these are all things that, as I say, so far as the appellants are concerned, are largely agreed, and we say that without asking that question, both Mr. Minhas was negligent in failing to ask that question, and it leaves this vacuum. We know what the upper end of the vacuum is, but we don't know how long the duration might have been, and in that vacuum, it was not appropriate to advise, because Mr. Minhas needed to know that information to be able to properly consider the available options for for Mr. Malik, and Mr. Malik in turn, in the absence of that advice, couldn't weigh up whether or not to live with the pain that he was experiencing as of that day, and await whether it was a week, a month, whatever period it might be, to see whether or not things had ameliorated. The second question.
Sorry, is that the end of ground one? Sorry, are those your submissions on ground one?
No, there's just one more point, which again sort of goes back to this question about the vacuumer lady. There was no finding about whether or not the pain continued to be present at the time the surgery took place, and the formulistic, as it were, part of the consenting process took place. So the actual filling in of the form, although it was agreed by Mr. Minhas that he had done the whole shooting match, as it were, on the 13th of July, that he'd received the new information, assimilated the new information, decided that surgery was the appropriate avenue, told that to Mr. Malik, obtained his consent, advising him as he saw them of the risks, and listed him for surgery. All of that was concertinaed into that one consultation, and the only bit that was left was for him to go and do, as I said, which is to physically requisition the surgery by filling in the form that he did. It was agreed that although that form had said sort of hand back to patient, actually that didn't happen in this particular case, because there was a difference in terms of the practice. So sometimes in some clinics you might hand a thing to the patient and they walk along the corridor to the desk and book themselves in, as it were. But Mr. Minhas filled that form in at the end of his consulting day and then took it down himself, all of which was clarified in the course of evidence. So this separate question is important set against the background of the uncertainty, because it was suggested by Mr. Ivanov in his evidence that in effect in those circumstances that are pertained on the 13th of July, one might take a more cautious approach if there was uncertainty about the onset, list for surgery provisionally, but then do some form of reassessment or consultation after the event. Now, the agreed position of the experts in the joint statement was that although that was something that some surgeons might do, it wasn't mandated, so it couldn't form the basis of a separate Bolam compliant decision. But it's if one accepts, as the courts have accepted, that consenting is a continuum, then one needs to be satisfied that the conditions that are met for surgery during the continuity of that process. So that brings me to the end of the position specifically in relation to the advisory component or the Bolam compliance aspects. Unless, my ladies, are there any questions from the court?
No, thank you. That's most helpful.
And hopefully deal perhaps a little bit more briefly with the consent aspects.
This is your second round of appeal now.
That's correct, my ladies.
Yeah.
And again, this is where we have the uncertainty that I mentioned about the current state of the law, because the case is working its way through. But we say, if one looks at the court, obviously clearly has done both of these purposes, and previously in the case of my lady, Lady Justice Davies, in the Diamond case, the experts were agreed. If one looks at the...
You want to take us to Diamond?
I don't think I necessarily need to prevail upon the court, directly. But if I can direct your attention to the two of the questions in the neurosurgical joint statement, so you'll find that in the supplemental bundle at page 295.
Yes, thank you.
So here the neurosurgeon set out the options in addition to the surgical intervention that was undertaken as being the wait and see and do nothing at that time. There was a qualification about that as to whether or not nothing meant absolutely nothing, or whether or not some additional pharmacological management might be explored at that stage. But Mr. Malik had some adverse experience with some medications and had limited pain relief from some others. So that essentially it was wait and see, tolerate the pain as it appeared.
The answer, the experts seem subject to looking at the injection, the nerve block. They haven't really answered in any detail the second part of the question, namely the respective benefits and disadvantages of such options.
That's in the circumstances that the pain specialists went into more detail in their respective joint statements, and of course that would have been there was a disagreement, or ultimately limited disagreement between the neurosurgeons about who would do what. Because some neurosurgeons are very hands-on in terms of doing alternative things alongside performing surgery, and some of them, if they've not got a scalpel in their hand and they're not using that, aren't really interested in what else goes on under somebody else's care. So there was essentially they were outlining what the options were.
So what we got, the question was, what are the options and what are the benefits and disadvantages? The neurosurgeons outlined the options: do nothing, refer to pain management.
That's correct, Malik.
Or do the nerve root block. They agree those are the options. They each say not a nerve root block. Neither of them comment on pain management or watch and wait.
No, because if there was a referral for pain management, then it would be in the hands of somebody else.
They don't give the benefits or disadvantages.
No. The benefits were outlined or considered in more detail in the joint statement of the pain specialist.
I'm just trying to, in my head, draw together where I find the information that underpins your ground two. So I don't find it in relation to the benefits or not of pain management and watch and wait in the neurosurgeon's.
No, my lady, no.
I can rule out nerve block.
No.
On the basis of this statement, but so far not the other two.
No, although there was a in terms of a difference about the enthusiasm of respective neurosurgeons about whether they would personally undertake these or they would ask one of their colleagues in pain management to undertake it. Some people are hands-on beyond that. I
wasn't actually thinking of what a neurosurgeon would in fact do. I was thinking more of what the experts were analysing.
They were mindful of the fact that there were already substantive reports from the pain specialists that went into more detail within their area of core expertise about these matters. So whereas one neurosurgeon might do the odd injection, certainly don't do as much as Dr. Valentine or Dr. Sanders would do in their clinical practice. So those were explored. But if it helps make it clear, I'm just focusing on the questions or the considerations, not necessarily the nuance of the treatments themselves, but whether or what were the options in the round, as it were. So those are set out and position maintained by the respective experts that the agreement didn't eviscerate at trial. And then separately, the question about linked to that was the answers to question 12 on page 298. So, in a sense, what were the options and what was reasonably required of the surgeon in terms of doing something with those options? My lady, can I just check what you actually ended up with bundles-wise? I know you said you read a very considerable amount of time, but what I will invite the court to do is to read the latter part of the re-examination of Mr. Ivanov, because he goes through.
You want to give us the page references so that if we haven't all read that particular part, we can go back to it. So we're in transcripts.
So it'll be pages 257, 258.
So would that be bundle 1 of the transcript?
Oh, sorry.
No, it's all right. Don't worry.
It's day 4.
It's bundle 2. Bundle 2.
It's the start of day 4. So trying to do everything on an iPad has some advantages, but it means that I'm not physically in bundles.
Don't worry, we'll find our way.
The advantages are as yet unclear to me.
So,
I'll give a full report in due course, my lord, whether it's helped me or hindered me today.
Transcript bundle 252, internal page, please.
Pages 75 to 79.
Try page 257 in that case.
Yeah.
Sorry, 257 and 258. So it's 75 to 79, my lady.
Excellent, thank you.
And in that, Mr. Ivanov goes through how he would suggest he would deal with this issue about the new information being given, what steps he would jump through. But my lady, it's important to recognise. My lady, I can give the court a moment to read through that. It might be helpful.
I think that. So you want us to read from page 75 through to 78.
75 through to 79. If I'm
Certainly. Just give us a moment, please. Thank you.
My ladies, it's important to qualify this bit of the transcript, if the court doesn't have the point already, that Mr. Ivanov wasn't saying this is what Mr. Minhas should do, but the reason why he was uncritical of Mr. Minhas is because his evidence was predicated on the basis of that is Mr. Ivanov's belief that the attendances in March of that year were indicative of the intercostal problems. So as far as he was concerned, the problem had been present, or the complaint had been ongoing since at least March of that year. So what he was saying was on the assumption that either Mr. Malik had complained of something entirely new, or at least, or alternatively, if there was some uncertainty about the duration, i.e. the patient couldn't say how long the new symptom had been present, or the new reported symptom had been experienced by the patient. So the point that we make is that is altogether removed from the exercise that was actually undertaken by Mr. Minhas when there was no good reason for him departing from that type of process. So we weren't saying that there should have been a second consultation, but in a sense the respondent can't have it both ways. It can't set up a false case, as it were, or false proposition through Mr. Ivanov and say, well, in effect the same route was reached in an alternative way. Mr. Malik needed to be told. They were quite clear. He needed to be told about what the different options were. There needed within that conversation to be an exploration about the duration of symptoms. Because Mr. Minhas hadn't informed himself about that question, he couldn't give consideration to that. He therefore couldn't consult and obtain consent from Mr. Malik. So what is a Boland breach for one purpose is also, we say, a collateral difficulty in relation to the position that Mr. Minhas obtained informed consent.
Well, as I understand it, my lady has already summarised it. The essence of the point is, if you don't ask the question, you don't inform yourself. Therefore, you can't give advice. Therefore, the patient can't give informed consent. That's it, as my lady summarised.
That's correct, my lady. Yeah. But in the same way that lawyers wouldn't be able to do that, we can't have a conference without reading the papers, taking clients' instructions, doing various different things. And the analogy is opposite in lots of different fields. We've all had clients who are desperate for something to happen. They might be desperate in a commercial context. People are no less desperate in that context, but in slightly more commonly encountered scenarios in family or medical matters, somebody might be desperate to achieve a particular end. But we would still, as lawyers, sit them down, explore the background circumstances with them, and counsel them against doing something that was rash. So you wouldn't start a boundary dispute on the basis that you'd had a neighbourhood dispute that had started that morning because you'd driven out of your path and had some sort of argue with somebody. Equally, you wouldn't get somebody to instigate judicial review proceedings on the basis that they were unhappy about something that had been on foot for hours or days. You'd see whether there was an amicable resolution that could be obtained. And similar considerations apply to lots of different things. And that's why I made the point about Mr. Minhas, because he was somebody that was very, very highly skilled, and he would think, well, it's in my power to do something about that. I want to get on with it and try and remedy the situation that this person finds themselves in. And I might think, in advising a client, well, I think we're going to have a successful outcome to this piece of litigation. Let's crack on with it. But I can't give a client any guarantee in those circumstances, so I have to qualify my advice to them. I'd have to say, well, we'll have to consider ADR, maybe have a little bit of a think about it because it might be quite expensive. I have to do that in the circumstances where I might have protection by quox, but obviously in other litigation contexts, I might be immediately making my client liable to very significant financial exposure in terms of costs. So these are all things that we're very used to dealing with. If it's incumbent upon us to do that in the circumstances that we operate, then it's clearly incumbent upon a surgeon to do that when they're potentially exposing their patient to a very significant risk of an adverse outcome. Relatively small percentage of something drastic going wrong, as it unfortunately did in Mr. Malik's case, and it's very difficult to disentangle this from other areas of professional practice where there is a need for a degree of caution, even if somebody is desperate or vulnerable or anxious or in pain, and the need to be cautious and considered in the advice and the approach that you adopt is perhaps more important rather than less important in those circumstances, because a patient as a client might be easily caught up in wanting to try and extricate themselves from the situation that they find themselves in. That's why we say it was so important for Mr. Minhas to take a breath. He didn't take a breath, and he proceeded to go through what would otherwise be ordinarily a much longer, or at least segmented process with the patient. And he jumped the gun. He was hasty for the best of intentions, but he was hasty, rash, whatever description you might want to place on it. And he lost sight of the need to carry Mr. Malik with him. My lady, I could probably deal, hopefully briefly, with the points in relation to causation. We certainly, I would hope, more simple in relation to the position over the Bolan-related complaint. So if the recommendation for surgery shouldn't have been made, or at least not made at that time, then the operation wouldn't have taken place. We're not in the realms of speculation about what would have happened all the way down the line, so we're not in a kind of Crossman type situation. But we've got an operation that shouldn't have been recommended to Mr. Malik in the way that it was recommended to him, and in consequence of that, he's had surgery shortly after that. The only way in which the court could be...
Sorry, can I just get this absolutely clear? When you say the operation shouldn't have been recommended to him in the circumstances that it was, are we coming back to your...
No, my lady. No, yes, we are, sorry, we're focusing on the time, because the time was critical. We know the time was critical because that informed whether there was a spontaneous recovery and whether or not any of the other avenues that weren't mentioned to Mr. Malik might have been effective in the circumstances. And I made the point earlier, but just to emphasise, it's not necessarily expecting there to be a complete resolution of symptoms. Perhaps that was unrealistic in itself, but certainly all that needed to happen for Mr. Malik to have thought differently about things with the benefit of time that he wasn't given was for there to be an assuaging of his symptoms. If they were of a lesser significance, then obviously the balancing exercise in terms of whether to subject yourself to surgery against the background of already having had a poor outcome first time around might well have weighed differently. The position in relation to informed consent, or the approach that we're taking. Sorry, there was one thing I forgot to put. So the only way in which you might purport to get, or defendants might look to get round that position, is saying, well, of course, even if he didn't have the symptoms on the 13th, it can be inferred that he had them when the surgery took place in August. But the problem with that, as I've said in the supplemental documents, is that we've got a complete vacuum about that as much as we have the first position. And this court will be highly alive to the risk that the patients get carried along. So somebody recommends something is happening to them. They don't go through the nuances of why why it's happening or whether it should continue to happen. And this was somebody in Mr. Malik's case that was going to have surgery in any event. As regards the lower part of the spine, I have great difficulty with my own neurosurgical experts when they're trying to explain to me which facet joint is going to do what, or which nerve root is going to do what. So one can't readily infer that because two sites were discussed, or certainly Mr. Malik's evidence about this in terms of how he was shown the scans didn't give anybody any great confidence that he understood what was being communicated to him. Now, I don't make any criticism in that regard about Mr. Minhas because it can be really quite difficult to understand an MRI. But it wasn't suggested to him that, well, he must have known you were having two-site surgery. He must have known there were two reasons for that. He must have had the symptoms. There wasn't an exploration of that against the background of the fact that, of course, Mr. Malik was saying that he didn't have any symptoms at all, so it would have been entirely an artificial exercise. But all we have is the document that is referenced that Mr. Minhas was taken to, which was the post-surgical nursing assessment. So that was the things like blood pressure, are you on any additional medication and so on. But there was no subsequent clinical examination recorded. There was no evidence called in relation to the consenting process itself to satisfy the court below that there was a repetition of what Mr. Minhas had recorded on the 13th of July. So when one comes to the separate question of the causation in relation to consent, we say, well, for reasons that I've given, essentially they're two sides of the same coin. It's a starting point that if Mr. Minhas had gone through the options, there's either a likelihood or at least a possibility that Mr. Malik would have adopted a different course. Had he adopted a different course, and the court's persuaded of that matter, then that's the end of the matter. But if the court finds itself in an intermediate position of just saying, well, because of these gaps, we really can't say what the position would be, then Mr. Malik finds himself in an analogous position to Mrs. Chester, and the default position should be that the appeal should be allowed on conventional, on this modified causation approach in Chester. If we got into the territory where it wasn't reasonable, there was no criticism about the time point, and we got into the territory where it was just the kind of nuances of the alternative treatment options, and I would accept that the appellants are then in difficulty.
Say that again, I missed that.
I would accept that the appellants are in difficulty. So if there were no complaint about the time point and the court rejects the position in relation to the criticism about negligence in relation to that, then it's an uphill struggle to overturn the court's finding.
My note to myself was that ground one was key.
Yes, my lord.
That's right, isn't it? I mean, the grounds 2 and 3 are, to a significant extent, parasitic on ground one.
They are, my lord, yes. It's just not possible to divorce the two, so to some extent they are. But I'm just countenancing the court not being with me in relation to ground one. I think the reality is, if you're not with me in relation to ground one, you're not going to find that there's any deficit in relation to. I have to be realistic, I think, in relation to that, my lady. If it just simply comes down to what would out of these different options on the assumption that the symptoms have been long-standing, then the reality is that Mr. Malik would have accepted, as he did, the recommendation of Mr. Minhas. His Honour Judge Blair didn't frame things in quite that way, but essentially he trusted, Mr. Malik trusted Mr. Minhas. So if Mr. Minhas had a reasonable basis for leaving out of the account the difficulty over duration, then the reality is that I would be stuck with a finding in relation to both the consent and the Bolam-related issues that precede it. just double check that there's nothing else that might be
Of course.
helpful to. If you consider it relevant, it may well be that it's not. But the bit that I mentioned in relation to Dr. Sanders, this kind of philosophical answering of the same question in a essentially the same way, but by a different route, was on pages. It was on day 4, and he was in the afternoon of the last day of evidence in the transcripts, and he explained his position. I think something's gone awry in relation to the pagination, but it's the internal pagination for day 4 is pages 167 to 176 to 179, and he explains there this point about, well, I don't know which category he fell in because of this uncertainty. He wouldn't commit to saying whether Mr. Malik in particular as a patient was one that was going to improve or not, because there wasn't the fraction of time that would have led to being clear about that. And a chronic condition starts with starts with a single day of discomfort. My lady, that brings me near, but not quite at the end of my submissions. I've still got the question about the pleading point, but I have set that out in full.
Yes.
And I would be unclear about where I could take the court further, but I don't know whether you want me to deal with that once you actually heard what my own friend has to say in reply, or whether you'd like to anticipate some of your own questions by asking me in addition.
Yeah, I think we've both read the skeleton. I think at the moment, subject to anything that we want to raise in due course, unless there's anything you want to add.
Just one point.
Of course.
Just because I think it's probably important for the appellants themselves to hear. If the court makes a criticism of the pleadings, then I'm happy to kind of fall on my sword in relation to that. I didn't anticipate it because it's just not something that I'd encountered. It wasn't something that was raised by Mr. Todd. There may be a criticism as to whether or not he or indeed any of the other experts might have given greater prominence to it. But it wasn't unexpected. And it's one of those things where people have asked about whether there is a disadvantage to conducting trials on a remote basis. It was one of those points that might have a greater prominence if it was accompanied by a collective intake of air at the time or some shaking of heads. It was just one of those things that was volunteered by or accepted by Mr. Minhas that was unanticipated, and I certainly didn't foresee it. But if there was a criticism of myself, then I accept that.
Sorry, Mr. Stockwell, can I just be clear? When you say it's not something I've encountered, what's the something you're talking about?
Somebody not asking about the duration, whether that's professionally or in my own course of being a patient. It's normally as it appears at the second question. Where does it hurt? How long has it been like that for? So it's just not something that occurred to me. If the court says, well, no, I'm sorry, Mr. Stockwell, that's not good enough, then I accept and, as it were, kind of apologise to the appellants, and I can't apologise to Mr. Malik in the circumstances. But I did my best to assist the court in terms of the pleading case below, as I hope to have done in this court, but it wasn't something that occurred to me. I've made the points, as I say, that I don't think that necessarily prejudiced the defendant. And the only other point to make is that, subject to anything my learned friend says, it doesn't appear that any actual prejudice is identified in the defence position. It can't be said that prejudice in having to meet a claim that you would otherwise have to meet is prejudice in itself, because that's been dealt with in other cases in this court in different contexts. For example, a limitation defence, section 33 and the like, there's no intrinsic prejudice in having to meet a claim that is otherwise valid. nothing's been identified as part of the exercise so far that meant that Mr. Minhas didn't have an opportunity, or Mr. Ivanov didn't have an opportunity to plug a gap. If I'm told otherwise in the course of submissions, then so be it. But I don't think I can assist the court further on the question of the pleading point, my lady.
Well, to use that hackneyed expression in the great traditions of the bar, your very gracious acceptance of that you were the person drafting the pleading is very welcome. And thank you.
Thank you.
Yes.
My lady, before I
Yes, Mr.
come to
Host.
the detail of responding to the appellant's submissions, may I address two overarching matters which I think put this appeal into context. My lady, the first, and this in a sense is what's been described as the pleading point, although actually in some ways it's wider than a pleading point, because it explains too that the evidence on which the appellant now relies was to a considerable extent not directed at the issues to which it's now sought to use it. My lady, so the first point made by the respondent is the claimant's case as advanced on this appeal was not advanced before the judge. My lady, therefore the criticisms of the judge for failing to determine that case are unfair and wrong. And my lady, the second point, which again relates very much to the issues on which Mr. Stockwell was submitting a moment ago, is that the issue of Mr. Minhas not being aware of the duration of the pain was not a new point that arose for the first time at trial. My lady, at the centre, so the first point is that the case presently before this court was not advanced below, and the centre of that case, as has rightly been identified, is that the responsible body of neurosurgeons would not have offered revision surgery in the absence of knowledge of the duration of the pain. And grounds 2 and 3 are as Lord Justice Coulson put it, parasitic on that. That contention was not advanced at any point at trial, either in the course of cross-examination or in the course of legal submissions. It is right that questions were put to Mr. Ivanov, although not to Mr. Minhas, the surgeon whose conduct is now impugned, about inquiry as to the onset of pain, and in particular about whether not inquiring as to the onset of pain was unacceptable.
I'm sorry, can I just catch that last bit?
I do apologise.
No, it's okay.
Questions were asked. The factual question was asked of Mr. Minhas as to whether he had asked about the issue. The cross-examination did not continue.
It was a one question and then it moved on.
Precisely so. It was not then said to Mr. Minhas that in that failure his treatment fell below an acceptable standard. The question was put to the defendant's expert surgeon, Mr. Ivanov, and Mr. Ivanov agreed a reasonable surgeon would want to know how long the pain had been present before offering surgery. But, again, crucially, it was not then suggested to Mr. Ivanov that without knowledge of the duration of the pain, a surgeon could not reasonably offer surgery.
I know I've read it, but can you actually give me the page reference?
But if
if you're going to take us at
the questions...
Not to Mr. Minhas, but to the expert.
At this moment, I've just trapped my gown in the chair. And therefore, I can probably do almost nothing at this moment. I can stand more or less foursquare exactly where I am. And my lady, may I say that I'll give you the page reference at a later point when I'm more flexible and mobile in my position, which is perhaps a bad analogy for a moment when one's dealing with a spinal surgery case. But my lady, what I say about that distinction as the issues that were raised with Mr. Ivanov is firstly this, that there may be many investigations that a reasonable surgeon would want to undertake before surgery. And maybe a typical example would be blood tests. One can easily see that an expert might say that a reasonable surgeon would want a battery of blood tests to be performed before offering surgery. It might very well be the evidence would be that mandatory. But, my lady, it may or may not follow that no reasonable surgeon could recommend surgery if all those blood tests were not performed. It's a separate step. There is an additional step in the argument between saying that an investigation is mandatory and saying that absent the results of that investigation, absent that part of the history, no reasonable surgeon can go on to the next stage of recommending surgery. But that was not the case at all advanced below. And even the halfway house of contending that failure to establish that the duration was negligent was not relied on in terms in the claimant's closing submissions. So as I say, there are two stages to the case as it's now put. Failure to ask is negligent, and that having failed to ask, the surgeon has not informed himself and cannot therefore inform the patient. That's, as it were, the two stages. But even the first stage is not put in closing because although argument is advanced about duration of symptom, duration of pain in closing, that argument is directed specifically at, essentially there are 3 points that are specifically advanced. And one of the easiest place to see this is within the core bundle, where my learned friend set out sections of the closing written submissions. This is at page 107 of the core bundle, paragraph 16. And there Mr. Stockwell sets out at paragraph 34 that the first point that's advanced is that it will be for the court to decide whether it's appropriate to recommend such surgery based on a single complaint of intercostal pain, and then to undertake it a month later. Not whether or not that it was appropriate to offer that surgery, given the extent of Mr. Minhas' knowledge of the history. No reference to the key words as the case is now brought, absence of inquiry or knowledge. Although that is now said to be absolutely central to the case that's advanced. The way the matter is put then goes on in paragraph 35. And there, the contention is advanced that there should have been confirmation of any thoracic symptoms on admission for surgery. And finally,
is that a reference? Sorry, forgive me. Is that a reference to the 13th of August?
My lord, yes.
Yeah. Sorry. Thank you.
My lord, and then at paragraph 38, the next development of the argument is that applying the approach in Wisniewski, JAH, the court should effectively conclude that if the intercostalgia was present, if the intercostal pain was present, it was of short duration and probably less than 6 weeks. The point being that a concession had been made by Mr. Ivanov in cross-examination that to operate where there was a history of less than 6 weeks would have been rash. And therefore, the approach taken by the appellant at trial was to invite the judge to make a finding of fact, applying the Wisniewski principle, that on that basis, the duration of symptoms was less than 6 weeks, and therefore surgery had been rash. And those are the same arguments that were advanced in oral argument. The case now put was not advanced in oral argument any more than it was in the written closing. And my ladies, my lord, what the respondent says is if that argument had been advanced, actually before I come to that, I say that if we look back at the appellant skeleton for this appeal, and we then see, in the light of the way the argument was advanced, we see strikingly the way that it is worded. And in paragraph 15, alleges that the judge erred in failing to have regard and consider as a relevant matter, not find as negligent as argued below, but it wasn't that. It's only a relevant matter. And my ladies, my lord, in the same way, when we read on through the skeleton argument, it is striking that paragraphs 17 to 26 of the appellant's skeleton are long on argument, but strikingly short on reference to evidence. There are two references. There are brief references to the judgment, and there are references to a discussion about whether references at paragraph 21 to the judge's ruling on whether questions could be asked, and finally at paragraph 26 of paragraph 5, the reference to the judge's comments on Mr. Malik. But what we don't see anywhere in this section is the core of the appellant's case in relation to the ground of appeal that is central to the entire appeal, is reference to evidence before the judge that supported that case. In effect, it's an argument that's advanced, that's floating, unsupported by a structure of evidence. And my ladies, my lord, the respondent says further that if the case that Mr. Manas could not properly recommend surgery in the absence of knowledge of the duration of pain had been advanced before the judge would have rejected it and would have been right to reject it because it was not what the claimant's expert neurosurgeon had said in his own expert report. I mean, that expert report is in the supplemental bundle at pages 104 onwards. The opinion section is at page 138, paragraph 109 onwards. And can I take, first of all, the court to paragraph 121, which is on page 141. And my ladies, my lord, first sentence in paragraph 121, I draw attention to now because it will be relevant to my second overarching point as to this matter not arising fresh at trial. The outpatient note of Mr. Minhas is clear in respect of what he will say. Mr. Todd was in no doubt of what Mr. Minhas's evidence in relation to this issue was to be. Then if we turn to page 142, to paragraph 123, if Mr. Minhas's evidence is accepted, and provided Mr. Minhas can demonstrate that intercostalgia was radicular pain and not neuropathic pain, because that was really the central issue at trial, yes, what the nature of the pain was, then both parts of the second operation could be justified. Strikingly not, and that radicular pain had been present for a prolonged period, but simply, if his evidence was accepted, there being no doubt about what that evidence was, both parts of the second operation could be justified. Maybe turning on to paragraph 127, Mr. Todd is critical of aspects of the letter. 127. On the basis of the outpatient letter, the benefits to surgery are difficult to calculate at this time because the nature of the pain and its distribution were not described. Strikingly, no criticism that there is no description of the duration or time of onset. And my ladies, my lord, that remained Mr. Todd's position throughout cross-examination. He did not at any point in cross-examination advance the case that absent knowledge of the duration of the pain, no reasonable surgeon would have offered revision surgery. On the contrary, what he said was that on the basis of Mr. Minhas's evidence, it was reasonable to offer surgery. That was the evidence that was before His Honour Judge Blair QC. And my lady, can I then, having made that point as to the case that was actually before the judge, deal with the point about this being a new issue that only arose at trial, and that therefore it would be unfair for the court effectively to shut him out on a pleading point. My lady, it's not right to say the point only arose at trial. The evidence on the nature of the pain consists of Mr. Minhas' clinic letter and his witness statement. The clinic letter is at page 10 of the supplemental bond. And the relevant sentence is a little more than halfway down the main paragraph. He no longer has to walk using a walking stick, but he is in terrible pain from the left side, with left-sided intercostalgia and left-sided sciatic pain all the way down his leg and into the foot.
And this was the first version of the letter, wasn't it?
Well, it is the first version. This is the version that had the word intercostalgia highlighted and the time stamp thereafter. There is another version, which I think isn't in the core bundle, which is identical, save only that it's no longer bold. There's no timestamp.
Right.
So I don't think I need to trouble your relationships. We're seeing the other version. But my ladies and my lord, I make the obvious point. Completely apparent to any reader of this letter that Mr. Menas has not there set out any information as to the duration of the pay or as to the date of its onset. Absolutely clear. And I believe that is not changed when Mr. Menas's evidence is then served. That's at page 91 of the supplemental bundle. And again, in paragraph 18, page 95, the description of the appointment. And there's a description in the third sentence of the pay. And again, no indication of any information, any knowledge of the duration of the pay. It's not, therefore, right to say that this is a jack-in-the-box that emerges in the course of the trial. At all times, the whole of the claimant's team, including Mr. Todd, must have been fully aware that there was no evidence as to the duration of the pain, but Mr. Todd does not advance that contention, and the particulars of claim do not advance that contention. When Mr. Menas was asked in evidence whether he had asked the date of commencement and said he hadn't, that merely confirmed that the position was indeed as set out in the letter and in the witness statement. And even after hearing that evidence, Mr. Todd did not say that absent knowledge of the duration of the pain, no reasonable surgeon could have offered negligent surgery. What he said was that on the basis of Mr. Menas' evidence, it was reasonable to offer surgery to the thoracic spine. Mr. Stockwell, in his supplemental skeleton, says that the respondent cannot take a pleading point because the issue was raised at trial and the judge effectively allowed the questioning to proceed.
Sorry, and the judge?
Judge allowed the questioning to proceed. No formal ruling was obtained preventing questions being asked as to the issue of whether it was mandatory to ask about the duration. But, my lady, that was, of course, only the halfway house. That question of was it mandatory to ask about duration was just the halfway house. And I return to my analogy of the blood tests. It's one thing to say that it's mandatory to carry out a particular investigation. It's quite another to say that if you do not carry out that investigation, no reasonable surgeon can properly recommend and offer surgery in those circumstances. The respondent cannot possibly be barred from raising a pleading point in relation to the latter because a judge allowed questions that went only to the former question of whether it was mandatory to ask the question. And my lady, I've I've shown you in the extract from the closing submissions the way that the point of action is applied. It probably be fair if I also relate it to one further point in the closing submissions where they are mentioned. It's still in the supplemental bundle. It's at page 375 of the supplemental bundle. And
375
of the supplemental bundle. I do apologise, my lord. My lord, this is the claimant's closing note,
Yeah.
which starts at page 372.
Yeah.
And the two paragraphs that deal with the issue, and I've taken the court to the sections where it's exerted in Bilal and Coulson.
No.
Didn't include paragraphs 15 and 16, and here too there is reliance on failure to ask about onset and duration, and here too we see the way the case is put in paragraph 16, not that no reasonable surgeon in those circumstances can proceed to offering surgery in ignorance, but instead simply the invitation to a judge to a benevolent assessment of the evidence and resolving doubt as to the duration. And, my ladies, my lord, what the respondent says about this being such a radically different new case is that there are two consequences that flow. The first, and the most fundamental to this appeal, is that this appeal is brought on the grounds that the judge was wrong, and not to find that no responsible body of surgeons would have offered surgery in the absence of knowledge of duration of the pain. But the judge cannot have been wrong not to find something that no one even suggested to him, and in relation to which there was simply no expert evidence on that point whatsoever. There was limited expert evidence obtained in cross-examination of the defendant's expert about it being mandatory, but no evidence that no responsible body of surgeons would have offered surgery in the absence of knowledge of the duration of the pain. That's the first. The second consequence is that taking the steps that the appellant invites this court to do and allowing the appeal on that basis would be unfair in multiple respects. Allowing the appeal on that basis would be, first of all, unfair to Mr. Minhouse. Secondly, it would be unfair to the respondent, and thirdly, of course, it would be unfair to the judge. As to the unfairness to Mr. Minhouse, that is a separate question to unfairness to the respondent. And in that respect, can I take the court to the authorities bundle at divider 19? 19. It's for Markan and Ziffer, or Ziffer, and it's a patent case, and this court need not be concerned with the facts, but as to some guidance on the importance of allegations being put to witnesses, which is at paragraph 56. that's at page 413. This is the judgment of Lord Justice Jacob, and the other two Lord Justices agreed. In the second, halfway down paragraph 56, but there is a second ground which we consider first, namely that procedure fairness, not only to the parties but to the witnesses, requires if their evidence were to be disbelieved, they must be given a fair opportunity to deal with the allegation. My lady, the point is then continued at paragraph 59 with an extract from the quotation, an extract from the judgment in Allied Pastoral, which in turn quoted from the case of Brown and Dunn, necessary to put to an, and this is the indented section in paragraph 59, 3 lines down. It is necessary to put to an opponent's witness in cross-examination the nature of the case upon which is proposed to rely on contradictory evidence, particularly where that case relies on inferences of fact. Rules of practice is necessary both to give the witness the opportunity to deal with that evidence and to allow the other party the opportunity to call evidence, either to corroborate that explanation or to contradict the inference sought to be drawn. My lady, the case here is slightly different, but the principle, the respondent says, is identical. The finding sought by the appellant is one that no reasonable neurosurgeon would have offered neurosurgery in the absence of inquiry, of knowledge about the duration of the pain. And if that were to be upheld, there would then be a finding of professional negligence, I do apologise, not misconduct, professional negligence against the surgeon, who the claimant's own expert, Mr. Todd, praised his skill. And that would be unfair both in general terms and for a series of specific reasons. And we say that for a professional man or woman to face criticism in relation to a matter that hasn't been put to him, and therefore face the possibility of a finding of professional negligence relating specifically to his conduct, is a matter that fairness requires properly be put to him. I mean, we say not to do so, but instead for a case to be advanced on appeal that is not put to that witness is unfair in general terms, and it's also unfair in very specific terms, which I will seek to illustrate by reference to 3 particular ways in which the new case will be unfair to Mr. Minhas. The first specific way is that it was not suggested to him that the failure to obtain a history of the duration of the pain amounted to a breach of duty. It was suggested to the defendant's expert, but it wasn't suggested to Mr. Minhas. And if it had been, we do not know what he would have said. But it is reasonable, in the light of his answers to the criticisms that were put to him, to say that he may have been able to explain that what he did was not a breach of duty on the basis of, firstly, the nature of the pain. Secondly, he may be able to explain it on the basis of the severity of the pain. And thirdly, he may have been able to explain the significance of the fact the disc was calcified, which he and the neurological experts explained made spontaneous improvement less likely.
goes back a stage further, really, doesn't it? Because the reality of any pleading is that pleading will have been taken generally from the opinion of an expert.
Yes.
So in the absence of a specific allegation of negligence, which there was here, that is the basis on which, for example, a witness statement would have been prepared. The witness statement would have stood as examination in chief at trial, and therefore cross-examination would ensue. So again, it's a stepping process, and all emanates, certainly in the experience of this member of the court, from the original expert's report.
Yes.
And none of it was there.
None of it was there. And what on earth would Mr. Minhas feel if he was sitting in the back of the court now? Earth would he feel? that it's being suggested that these criticisms can properly be advanced against, that were that are effectively wholly absent from the evidence of the claimant's case. And of course, that was simply my first example. The second example is that it wasn't suggested to him that failure to obtain the history vitiated his ability to recommend surgery. Again, we can't know what his evidence would have been. But again, we can consider his responses to the questions that were put to him. And I submit that he may have been able to explain. Of course, it's speculation, but all we can do is speculate in the light of the answers to the questions that were put to him. Explain why not, in the light of his assessment of the nature of the pain, the severity of the pain, the prospects of success of surgery, and the prospects of success of alternative treatment. He may also have explained the significance of Mr. Malik being desperate for surgery. And my third example is that it was never put to Mr. Minhas that the duration of pain is relevant to the prospects of spontaneous resolution, of pain relief, and the likely success of alternate treatments. We, again, don't know what he would have said to those. We can have some idea from the questions that he was asked about the merits of alternative treatments, and those were summarised by the judge at paragraphs 53 to 57 of the judgment. But he can't know, because he wasn't asked. So my first freestanding argument of unfairness is the unfairness to Mr. Minhas himself. And the second is the unfairness to the defendant, because this case was not put to the defendant's expert surgeon. It wasn't put to Mr. Ivanov. The more limited issue of whether Mr. Minhas should have asked about the duration of pain was put. But the appellant's case that absent knowledge of duration, Mr. Minhas could not properly recommend surgery or properly advise as to alternatives was simply not put. And my lady, my third entry in my list of unfairnesses is, of course, the unfairness to the judge, because that's obvious.
I'm sorry, I missed that.
The unfairness to the judge. It's obvious, it's unfair to say that a trial judge is wrong in not finding something that is not put, not advanced in front of him. My ladies, my lord, I'm about to come on to another point, and I'm conscious of the time. Is that a good moment?
Yes, certainly. Thank you very much. 2 o'clock, please.